The DS rule is changing for F-1, J-1, and I visa holders. Hello everyone. Today we are talking about a very important new immigration rule for F-1 students, J-1 exchange visitors, and I visa holders. This rule is very new and I'm going to share you the most updated information we have, but as DHS, USCIS, SEVP, schools and exchange visitor programs release more guidance, we will continue to keep you updated. The Department of Homeland Security has issued a final rule ending the duration of status system, also known as DS, for F, J, and visa classifications. This is a major change. For many years, F1 students and J1 exchange visitors were admitted to the US for duration of status instead of a specific end date. Now, DHS is replacing the DS with a fixed period of admission. That means these visa holders will have a specific authorized period of stay. They will need to pay close attention to their I-94, their I-20 or DS 2019, their program end date, and any future extension requirements. This rule is also especially important for students in English language programs because language schools are now limited to 2 years in total, including breaks and annual vacation. The listed effective date for the rule is September 15, 2026, subject to congressional review. So what you do right now before September 15, 2026 becomes very important. Because this rule is new and implementation guidance is still developing, students should not wait until the last minute to review their status. Let's break this down. What is DS? DS stands for duration of status. Under the DS system, many F1 students entered the US with DS written on their I-94 instead of a specific expiration date. This means that the student's authorized stay is connected to maintaining valid F1 status, but this is about to change. For F1 students, maintaining status means attending school full-time, keeping a valid I-20, following all F1 rules, avoiding unauthorized employment, and properly completing any authorized OPT or STEM OPT period. For J1 exchange visitors, DS is connected to the authorized exchange program listed on the form DS 2019. For I visa holders, DS is generally connected to the period of authorized foreign media employment in the United States. The important point is this. Under DS, the I-94 usually did not show a specific expiration date. Now that is changing. What is changing? Under the new rule, F, J, and I visa holders will be admitted for a fixed period of time. For F1 students and J1 exchange visitors, the admission period will generally be based on the length of the program, but it cannot exceed 4 years. 4 years is the maximum amount of time that will be given in each entry. If the program is shorter than 4 years, the admission period will be tied to the program length. If the program is longer than 4 years, the student or exchange visitor will need to take additional steps to remain in the US beyond the authorized period. This is where extension of stay becomes very important. What is extension of stay? An extension of stay, also known as EOS, is a request filed with USCIS to extend the period of authorized stay in the US. Under the new rule, students and exchange visitors who need more time beyond their fixed admission period will need to apply for an extension of stay through USCIS. This is a huge change. Before this rule, F1 program extensions were mainly handled through the school and CVIS. Now, for students who need additional time beyond the fixed admission period, USCIS will have a more direct role. This means the student's immigration timeline becomes much more important. So students must track not only their I-20 program end date, but also their I-94 expiration date and any USCIS filing deadline. What happens to current F1 and J1 holders? Current F and J visa holders who are already in the US under the DS will transition into the new system. Every student needs to review their documents carefully and understand when their authorized period ends under the new rule. Students should review their I-94s, I-20s, DS 2019s, EAD cards, program end dates, any upcoming academic or employment plans. So, for example, if your I-20 is valid for 6 months after September 15, 2026, your I-94 will be transitioned into a 6-month I-94. This is what we understand from the regulation. However, there may be different transition programs allowing current F1 students to get more time. We still don't know what the exact transition plan is, and we are expecting for more updates. OPT and STEM OPT are also very important under this rule. Students need to understand that an I-765 work permit application and an extension of stay application are not the same thing. The I-539 extension of stay is about students' underlying immigration status. If your status ends, you will extend your status with this form. Under the transition rules, certain F-1 students with timely filed post-completion OPT or STEM OPT applications have special treatment. But students should not assume that filing for OPT automatically protects their status in every situation. This is exactly why timing is so important. Before filing for OPT, STEM OPT, or any extension, students should speak with their DSO and review whether an extension of stay is also required. Another important rule change is the grace period timing. Previously, F-1 students had 60 days after completing their program or authorized post-completion practical training to prepare for departure, transfer, or take other action. Under the new rule, that period is reduced from 60 days to 30 days. This is very important. Students will have less time after program completion to make decisions. That means less time to transfer schools, change status, prepare to leave the US, or take another immigration step. Planning ahead is now much more important. How about school transfers and program changes? The new rule creates stricter rules for F-1 students who want to transfer schools or change educational objectives. In general, F-1 students changing schools or educational objectives must complete the first academic year at the school that initially issued the Form I-20 unless SEVP authorizes an exception. For graduate level students and above, the rule is even stricter. Graduate level F-1 students are generally prohibited from changing educational objectives during the program. Graduate level F-1 students are also generally prohibited from transferring during the program unless SEVP authorizes an exception for qualifying circumstances. The rule also limits the ability to move to the same or a lower educational level after completing a program. So the practical message is this: students should not assume that school transfers, program changes, or starting another degree will remain as flexible as before. Before making any academic change, students should speak with their DSO and review the immigration consequences. Another very important change is for language schools or ESL schools. Under the new rule, F-1 students in language training programs are limited to an aggregate 24-month period of stay. That means language school is now limited to 2 years in total. This 2-year limit includes breaks and annual vacations. This is a major change for students who have been attending English language programs for a long time or who are planning to continue in language school before starting another academic program. Students in language schools should review their I-20 dates, their full immigration history, and their long-term academic plans immediately. The practical message for language schools is simple. Language school can no longer be treated as an open-ended way to remain in F-1 status. If a student's long-term goal is to continue studying in the US, they should speak with their DSO and carefully plan the next step, such as a certificate program, a college program, university program, or a graduate program. How about traveling in F-1 status? Travel becomes much more important under this rule. After the effective date, a person who travels and re-enters the US can receive an I-94 with a specific expiration date instead of DS duration of status. Before traveling, students should review their passport validity, visa validity, I-20 travel signature, CV status, program end date, OPT or STEM OPT status, and any pending USCIS applications. Travel while an application is pending can create serious complications. Students should not travel without reviewing the consequences first. What should you know? First, check your I-20. Then check your I-94. Third, check your passport and visa validity. Fourth, speak with your DSO about how your school is implementing this rule. Fifth, if you are an OPT or STEM OPT, review your EAD expiration date and your future filing timeline. Sixth, if your program will take longer than expected, start planning early. You may have to apply for an F-1 visa at the consulate, or you may have to file an extension of stay in the US. Seventh, if you are considering a school transfer, program change, or a new degree, review the new restrictions before taking action. Eighth, keep copies of all immigration documents, including I-94 records, I-20s, DS-2019s, EAD cards, approval notices, Transcripts, enrollment letters, and proof that you maintained status. This rule makes timing and documentation much more important. This rule does not mean every F1 student has to leave the United States immediately. It does not cancel valid F1 status for students who are properly maintaining status. It does not mean every student is out of status. It also does not eliminate OPT or STEM OPT. It does not eliminate the role of the DSO. On the contrary, the role of the DSO is elevated. But it does change how students must think about their status. Students can no longer rely only on DS. They must track specific dates and take timely action before their authorized period ends. For example, in the past, maybe you were thinking about going to a language school for 3 months, and then you would decide what to do afterwards. Now you have to plan accordingly. Maybe you have to choose a program that is 6 or 12 months in total because you don't want to be dealing with USCIS all the time for all extensions. So try to plan carefully and try to get as much time as possible on your I-20s. So what does extending your period of stay with USCIS look like? You have to file a Form I-539. You have to prove that you were maintaining your status and you are eligible for the new extension of status. So you are basically going under USCIS review to get a new extension. If you have a longer period of I-20, that is better for you because you would not need to file an extension of status with USCIS. You don't have to go through the expenses that is involved with the 539, and you can get a longer period of stay in the US. I think what USCIS is trying to do is trying to control the students better. By giving them a fixed period of time instead of duration of status, you will be under constant USCIS or CBP control. Think about a student who leaves the US and comes back on an F1 visa. He will be given the I-20 end date for the I-94 expiration. Either has to leave or extend status with USCIS. It's the same thing with filing extension of status. USCIS will control if you maintain your status and if you are eligible for the new F1 stay with that application. In closing, this is one of the most important changes for F1 students, J-1 exchange visitors, and I-visa holders in many years. DHS is ending duration of status and replacing it with a fixed period of admission. This means students and exchange visitors must be more careful with I-94 dates, I-20 and DS 2019 end dates, OPT and STEM OPT timelines, school transfers, program exchanges, travel plans, extension of stay filings, and language school limits. You have to plan in advance and accordingly. For language training students, the message is very important. Language schools are now limited to 2 years total, including breaks and annual vacation. You cannot use language schools to linger in the US. But don't forget, this rule is very new. As Department of Homeland Security, USCIS, SCBP, schools and exchange visitor programs release more guidance, we will continue to keep you updated. Every case is different. Before making decisions about travel, school transfer, program change, OPT, STEM OPT, language school enrollment, or extension of stay, speak with your DSO and consult with an experienced immigration attorney if your situation is complicated. If you have any questions, you can reach out to me in the comment section and I will try to respond as much as I can. If this video is helpful, please like, subscribe, and share it with someone in F1, J1, or I status who needs to know about this new rule. Thank you for watching. See you in the next video.
Ha!